Imagine this. The air in a courtroom, thick with history, with ceremony. Robed judges, the hushed tension of onlookers, the weight of justice hanging in the balance.
Hmm.
But sometimes the secrets aren't just about the case being argued before the bench. Sometimes they're about the people standing right there, seemingly upholding the law.
Absolutely.
And sometimes those secrets are buried so deep they threaten to shatter a career, a reputation, a life built from the ground up.
It's absolutely true. The halls of justice, the legal profession itself, demands a level of transparency and integrity from its practitioners that can feel almost, well, impossibly high for anyone carrying a burden or a difficult truth from their past.
Yeah,
And when that past involves not just a mistake, but a deliberate act of concealment to gain entry into that profession, the system can be incredibly unforgiving.
that's exactly what draws us to the story we're diving into today. We're looking at the case in Re Davis, decided back in 1947. And this isn't just a dry legal precedent. Think of it more like a gripping, real-life legal drama, almost a true crime saga played out in the courtroom.
Definitely has that feel.
It's the story of Samuel Wilton Davis, a man who climbed his way from a troubled youth, faced serious criminal charges, received a second chance, and through years of hard work, finally achieved his dream of becoming a barrister.
An incredible journey on the surface.
Only to have his hidden past surface, leading to a dramatic fall. And the crucial point is, he wasn't undone for the crime he committed years ago, but for the stunning fact that he chose to keep it a secret when he sought admission to the bar.
And that's the key distinction, isn't it? This case wasn't a criminal trial rehashing those old offenses. That was done and dusted, legally speaking.
Right.
This was a professional reckoning, a disciplinary action brought by the very court that had sworn him in. The core question wasn't his guilt for the original crime, but whether a man, despite a decade of apparent rehabilitation, was truly fit to remain an officer of the court after obtaining entry by concealing a fundamental truth about his history.
It really challenges that whole idea of rehabilitation versus the absolute need for candor, doesn't it?
It absolutely does. Where do you draw the line?
Our mission in this deep dive is to unpack this whole incredible story for you. We're going to trace Davis's journey step by step, his rise from the shadows of a conviction to the hallowed halls of the bar, the process he went through to get there, and the critical choices he made along the way.
We'll follow his procedural journey through the courts, too, from, the initial discovery of his secret right through the dramatic showdown in the Supreme Court.
And finally, to the definitive last word from the highest court in the land.
Exactly.
And, perhaps most importantly, we're going to explore this as a stark, powerful, cautionary tale, one that holds vital lessons for anyone today aspiring to practice law, or indeed, for anyone who believes their past is best left buried.
There are surprising facts here, definitely. Immense human drama and the stakes. Well, they literally couldn't have been higher for Samuel Davis. His entire future was on the line.
It's a story that still resonates profoundly, I think, because it highlights critical legal principles that are just as relevant today as they were back in 1947.
Principles about candor, absolutely. About character and the unique trust that is just inherent in the legal profession. You have to have it.
It's a tale that forces us to ask, how much does the past really matter when someone is trying to rebuild?
And critically, is hiding that past ever justifiable, especially when you're seeking entry into a profession that's fundamentally built on truth?
So settle in. This is the deep dive, and we're heading back in time to 1947 Sydney to uncover a secret that brought a barrister's world crashing down and the enduring lessons it holds for us today.
Let's begin by setting the scene for the pivotal moment, the climax, really, of this whole story.
Okay, let's set the stage. Transport yourself, if you can, back to Sydney, October 1947. We're in the Bonko Court of the Supreme Court of New South Wales.
A very imposing room, historically.
And the place is packed. Not just with the usual lawyers, their clerks, and litigants, but likely with members of the bar, solicitors, curious onlookers, drawn by the gravity, maybe even the scandal of what's about to unfold.
You can imagine the whispers. On the bench sit three robed judges, figures embodying the authority and tradition of the Supreme Court. Presiding is the Chief Justice, Sir Frederick Jordan.
And a big name.
By all accounts, a formidable jurist, known for sharp intellect and, importantly, for upholding strict standards. Sitting alongside him are two Puene judges, Justice Davidson and Justice Treat. These are the men who hold the power in this room, They'll decide his fate and, in doing so, uphold the integrity of the legal profession.
And then at the bar table, the place where advocates stand, robed and wigged, to plead the cases of their clients, stands a young barrister. This is Samuel S.W. Davis.
But today, he's not there as counsel for someone else.
No. He is the man facing the court's scrutiny, the respondent in a disciplinary hearing brought against himself. The air must have been thick with tension, a palpable silence hanging over the courtroom as these legal titans prepared to debate his future.
The core conflict is laid bare right from the very beginning of these proceedings. Samuel Davis carries a shocking secret from his past, a secret that, perhaps paradoxically, might have been one of the very things that fueled his incredible drive to succeed.
To prove himself.
Exactly, to build a respectable life. But now, that same secret threatens to undo it all in disgrace. As you mentioned, this wasn't a criminal trial rehashing the old offense that was dealt with years ago.
Right.
This is about his fundamental fitness to remain a barrister. It's a question of whether a man, despite a decade of apparent rehabilitation, was fit to be an officer of the court after obtaining entry by concealing a fundamental truth about his history.
It immediately frames the entire story as this incredible legal saga, doesn't it? A narrative of a remarkable rise and a potentially devastating fall.
It really does. And it's a powerful, timeless warning that in the world of law, integrity isn't just some abstract concept or a nice idea.
No, it's fundamental.
It is the absolute bedrock of the profession, the very foundation upon which everything else is built. And as Samuel Davis was about to discover, in the most painful way possible, secrets are incredibly difficult to keep, especially in a profession built on trust, transparency, and absolute honesty.
To really understand the depth of what was happening in that courtroom in October 1947, it helps to know who the key players were in this drama. Think of them as the central characters in this legal unfolding.
Good idea. Let's map out the dramatis personae, so to speak.
Absolutely. Let's introduce the cast of individuals who played a role in the Henry Davis saga, giving them a bit of color and context as characters in this real-life legal drama.
Okay, at the very center, of course, is Samuel Wilton Davis, our protagonist. He's the barrister with the hidden past. We know he was admitted to the NSW Bar in 1946, so he's relatively new.
Just a year in practice, roughly.
Yeah, and he is the respondent in this action, the person called upon by the court to appear and explain himself, now facing the potential loss of his career through disbarment, specifically for concealing that prior criminal conviction.
Then you have the three imposing figures who would preside over the Supreme Court hearing and decide his fate. Sir Frederick Jordan, CJ, the Chief Justice of New South Wales.
The top judge.
Exactly. He's the most senior judge presiding over the 1947 hearing and, crucially, the one tasked with delivering the considered judgment of the full court. Imagine him as one of those austere, perhaps intimidating figures in black robes, embodying the weight and authority of the law itself.
Sitting alongside the Chief Justice were the two other members of the judicial panel, the Poison judges, Justice Davidson and Justice Street. They participated in the full court hearing, hearing the submissions from both sides, and contributing to the collective decision on Davis's future at the bar.
And it's worth noting, as you pointed out from the source, the junior barrister assisting the Bar Association was also named Mr. Street, but explicitly not related to the judge.
Correct. A potentially confusing coincidence, but they were distinct individuals.
Now, representing Davis, he brought in some serious legal firepower. His leading counsel was none other than Garfield Barwick K.C.
A legal legend indeed.
The source describes him that way, and he certainly went on to have an incredibly distinguished career, becoming Attorney General and eventually Chief Justice of the High Court of Australia.
A giant of the law.
At this time, though, he was a brilliant King's Counsel, a formidable advocate, facing what the source accurately terms a Herculean task, arguing in defense of Davis's admission and fitness to remain at the bar.
He had his work cut out for him. Barwick was assisted by a junior counsel, Mr. Clifton.
And on the other side, who was arguing against Davis?
Representing the Bar Association, whose role in these disciplinary proceedings was essentially to assist the court by presenting the facts and arguments relevant to maintaining professional standards, was Clifton Fuller K.C.
Another King's Counsel.
Yes, a senior barrister and King's Counsel himself. Described in the context of the arguments as effectively the steel-eyed prosecutor, presenting the case for why Davis should be removed from the role. Fuller was assisted by his junior barrister, the unrelated Mr. Street.
And handling the behind-the-scenes legal work, providing instructions to the barristers, were the solicitors. Who were they?
Okay, so for Samuel Davis and his defense team, Barwick K.C. and Mr. Clappin, The instructing solicitor was K.V. Swain.
Got it.
And for the Bar Association and their counsel, Fuller K.C. and Mr. Street, the instructing solicitors were the prominent Sydney law firm Allen and Hemsley.
A major firm, even then.
Absolutely. Now, there is a slight note in one scanned document that seems to flip these roles at the very end, but the overwhelming narrative and the description of the hearing itself strongly suggest Allen's acted for the Bar Association here and Swain for Davis. So we'll proceed with that understanding.
Okay, that makes sense contextually. And there were two other crucial figures, weren't there? The solicitors who provided the references.
Yes, pivotal figures, though perhaps unwittingly so at the time. These were Mr. J.R. Wishart and Mr. K.G.G. They were the two unsuspecting solicitors who provided those vital character certificates for Samuel Davis when he initially applied for admission, vouching for his good fame and character.
And the key thing is,
Crucially, as we'll detail, they were completely unaware of his criminal past when they did so. Their testimonials were essential to his admission, but their ignorance of the truth would later become part of the evidence against Davis, highlighting his non-disclosure.
so that's our cast of characters in this legal drama. With the players introduced, let's rewind the clock significantly. To truly understand how Samuel Davis, with these formidable legal minds debating his fate, ended up in this incredibly precarious and public position.
We need to go back, way back.
Exactly. We need to go back to the beginning of his story, long before he ever dreamed of stepping into a courtroom as a barrister.
Our story really begins not in the polished, tense environment of the Bonko Court in 1947, but on the, well, rougher, less forgiving streets of 1930s Sydney. Samuel Wilton Davis was not always the aspiring or practicing barrister we just described. His youth was marked by significant struggles, particularly with his mental health, which cast an early shadow over his life.
The source material paints a picture of a young man facing considerable challenges. We're told that in 1933, when he was just 19 years old, Davis suffered what was described in rather dated terms as some degree of mental derangement.
Yeah, the language was different then.
This was serious enough to lead to his formal admission to the Callan Park Mental Hospital in September of that year. He remained institutionalized for several months, eventually being released on leave in May of 1934.
But sadly, achieving a measure of freedom didn't immediately bring stability or perhaps better judgment. Just a few months after leaving the hospital, on the night of September 18, 1934, the 20-year-old Samuel Davis made a fateful and life-altering decision.
He joined up with two companions, a man named Murray and a woman named Wilson, in a plan to commit burglary.
Why? What was the motivation?
The source suggests they were motivated by financial strain at the time, and perhaps, given his recent mental health struggles, Davis was exercising with simply poor judgment. A bad decision, basically.
And their target.
A residential flat in Bondi. It belonged to a Mrs. Jones, who the source indicates was an acquaintance of Davis. He knew she kept valuables there and, tragically, believed it would be an easy score.
Oh, dear. So he knew the victim. How did he get in?
They attempted to gain entry first through a fanlight window above the door, but when that proved difficult, Murray simply forced the door lock to gain entry.
And what did they take?
Once inside, they weren't looking for small change. They took a large haul of clothing, jewelry, and other goods. The total value was estimated to be around 140 pounds.
Which was a lot of money in 1934.
A substantial sum, absolutely. Unfortunately for Mrs. Jones, only about 90 pounds worth of the stolen items was ever recovered by the police later, suggesting much of it was quickly disposed of.
So what happened next? Did they get caught quickly?
Yes. In the immediate aftermath, when the police caught up with him, Davis's first instinct was to try and avoid responsibility by lying. He initially spun a story to the authorities about a fictional man named Jackson being the real culprit.
Trying to pass the buck.
But, as often happens with lies, especially under pressure, it didn't hold up for long. His story quickly fell apart, and Davis eventually admitted the full truth about his involvement in the burglary with Murray and Wilson. He was caught, as the saying goes, red-handed, in a serious offense of breaking, entering, and stealing.
At this point, his future must have looked incredibly bleak. Prison seemed like the most likely outcome for a convicted felon, especially for burglary.
Absolutely. But here is where the story takes a significant turn. A moment of fortune and, importantly, a measure of judicial mercy that would grant Samuel Davis an unexpected second chance.
Okay, so the trial itself.
On March 5, 1935, he appeared before a judge to face the charges. He entered a plea of guilty.
He owned up to it in court.
Yes. During the court proceedings, a medical witness was called to testify. They stated that despite his recent history of mental health issues, Davis was perfectly sane at the time he committed the crime, implying his actions weren't directly a result of ongoing derangement.
But the judge noticed something.
Yes. The judge presiding over the case himself observed that Davis's demeanor in the dock was most peculiar, perhaps noting some lingering effects or nervousness, maybe just the stress of the situation.
And then came the pivotal moment of leniency.
Exactly. Instead of imposing a prison sentence, the judge decided to release the 20-year-old Davis on a good behavior bond.
Ah, okay. So not jail time. What did the bond involve?
It required him to enter into a personal bond of £100 and find a surety provided by his mother for another £100. The conditions attached to this bond were clear and strict. He had to stay out of trouble, not commit any further offenses for a period of 3 years.
Standard conditions.
And he was required to avoid his accomplices, Murray and Wilson. Stay away from bad influences.
Right, and the consequences if he breached it.
The terms were crucial. If he reoffended or breached any of the conditions within that 3-year period, he could be summoned back to court and sentenced for the original 1934 crime, potentially facing a significant prison term.
So the sentence was hanging over him.
Exactly. But if he successfully met the conditions, if he stayed clean and behaved himself until March 1938, he would never serve a single day in jail for that burglary.
This was an absolutely critical moment in Samuel Davis's life. An act of judicial mercy that spared him incarceration and gave him a genuine, tangible chance to rehabilitate himself and rebuild his life outside of the prison system.
He walked out of that courtroom in 1935, a free man, yes, a convicted felon, but with no prison record. He had been given an opportunity to truly wipe the slate clean, in practice, if not in legal record.
The big looming question at that moment was, would he take full advantage of this incredible chance, or would he squander it?
And as it turned out, for many years, Samuel Davis absolutely chose the path of rehabilitation. He seemed to embrace this second chance with remarkable earnestness and determination.
That's interesting. So he did turn things around.
It appears so. Released on that good behavior bond in 1935, the source tells us that Davis made a conscious decision to put distance between himself and his past. He left New South Wales shortly after the trial and moved to Queensland.
A fresh start. Probably a smart move. Get away from the old scene.
Likely a strategic move, yeah. Away from the environment and the associations that had led him into trouble, and away from the local knowledge of his conviction.
And this fresh start seemed incredibly successful. The court records and later accounts acknowledge that from about 1935 onwards, for a solid decade, Samuel Davis genuinely led an honest, industrious, and studious life. He found stable employment and dedicated himself to living a law-abiding and respectable existence, successfully fulfilling the conditions of his bond until it expired in 1938.
Life milestones followed, indicating he was integrating into conventional society. In 1938, around the age of 24, Samuel Davis got married, marking his entry into settled family life.
Okay, settling down. What about work?
Professionally, he also saw significant growth. By late 1940, he had advanced to become a sales manager for National Cash Registers (TT Ltd) for the North Coast region of New South Wales.
NCR. That's a big company. Sales manager is a responsible position.
Absolutely. Significant responsibility, managing staff and sales territories, requiring trust and reliability proof he had proven himself capable and trustworthy in the working world.
What about during the war years?
As World War II took hold, Davis demonstrated further commitment. He attempted to join the military to serve, but he was rejected as medically unfit.
Likely due to the earlier mental health history.
Probably. Undeterred, he moved back to Sydney in 1941 and took up war-related industrial work, specifically securing a job in a munitions factory on the home front, contributing to the war effort despite being unable to serve abroad.
So, doing his bit.
By the early 1940s, the transformation appeared complete. On the surface, Samuel Davis was a respectable, hard-working, married man who had contributed to the war effort. Few who met him, who saw his diligent work ethic and stable life, would ever suspect the dark chapter of his youth.
The mental hospital, the burglary conviction.
Exactly. He had, to all external appearances, seemingly erased the blemish of that 1934 crime through years of exemplary conduct.
But quietly, alongside his work and family life, something else significant was taking shape in Davis's ambitions. Around 1944, perhaps driven by a deep desire for ultimate respectability, or maybe a form of atonement for his past actions.
What happened?
The then 30-year-old Samuel Davis set his sights on what many would consider an incredibly audacious goal for someone with his history. He decided he wanted to become a barrister.
Wow. That is audacious.
Incredibly bold. The bar, more than almost any other profession, places an immense value, a premium on impeccable character and absolute integrity. It's built on trust.
And he must have known his past could be a problem.
He was acutely aware that revealing his 1935 conviction, even though it hadn't resulted in prison time thanks to the bond, could easily scuttle his chances of ever being admitted.
Right.
Yet, after a decade of seemingly successful and genuine rehabilitation, maybe he felt that chapter was truly behind him, a youthful mistake overcome, and perhaps best left unsaid when seeking entry into this high-minded profession.
That internal conflict, to disclose or not disclose.
This moment of decision about what to disclose and what to keep private would prove to be absolutely fateful for Samuel Davis.
With this audacious dream in mind, Samuel Davis began the formal, multi-step process of seeking entry into the legal profession, a process that hinged entirely on satisfying the gatekeepers of his good fame and character.
That's right. The first formal step came on May 3, 1944. He submitted his application to the NSW Barristers Admission Board to become a student at law.
The standard pathway, then.
Yes, often done concurrently with university studies.
And the key hurdle, even at this stage.
Character. A critical requirement for this application, as mandated by the Legal Practitioners Act 1898, specifically Section 9, was that a candidate had to satisfy the Barristers Admission Board that they were a person of good fame and character.
How did they assess that?
The rules in force at the time required applicants to provide written certificates from two sponsors, typically established legal professionals or other highly respected individuals in the community who could personally vouch for the applicant's character based on their knowledge of the individual.
And Davis provided these.
Davis provided the required certificates. They came from two solicitors who evidently knew him and were respected members of the legal community, Mr. J.R. Wishart and Mr. K.G.G.
The same names you mentioned earlier.
Exactly. We can presume these were professional contacts or acquaintances who had observed Davis living an upstanding, hard-working life over the previous decade. In their written testimonials, both solicitors formally affirmed that, in their honest opinion based on what they knew, Samuel Davis was indeed a person of good fame and character.
And here, buried within this seemingly positive step, lies the crucial damning omission that would later be his undoing.
Yes, Davis never told them about his 1935 conviction for breaking, entering, and stealing. Neither Mr. Wishart nor Mr. G had any inkling whatsoever of his criminal past when they provided those glowing character certificates.
No, they testified to that later.
They would later swear under oath in court that they were completely ignorant of this significant fact when they vouched for him.
And Davis himself on the application.
When Davis submitted his formal application and these certificates to the Barristers Admission Board, he himself made no mention whatsoever of the 1935 conviction.
Was there a specific question asking about convictions?
The source notes a critical detail here. There wasn't an explicit direct question on the application form at that time asking something like, have you ever been convicted of an offense?
A loophole maybe, he thought.
And Samuel Davis, seeing this apparent ambiguity, took full advantage of that ambiguity, as the court later found. He made a conscious and deliberate choice. Silence over candor. He was effectively burying his criminal past from the very people who were meant to vet his character.
So the board receiving these glowing references.
The Barristers Admission Board, receiving glowing, unqualified character references from two reputable solicitors, and seeing that Davis met the other academic prerequisites, approved his application as a student at law.
And then he hit the books.
Davis then diligently pursued his legal studies, enrolling at the University of Sydney Law School and completing the required coursework, eventually earning his Bachelor of Laws degree. The source rightly notes that this was no small feat, acknowledging his perseverance in balancing studies with his job and wartime work during this period.
He really did work hard for it.
He absolutely did. By late 1945, armed with his law degree and the board's initial clearance as a student at law, he was ready for the final step: the formal application for admission to practice as a barrister before the Supreme Court itself.
Okay, the final hurdle. So early 1946.
Davis needed to satisfy the character requirement once more for his formal barrister's admission. And, perhaps predictably, he returned to the same two referees who had previously vouched for him, Mr. Wishart and Mr. G.
Still unaware.
They provided character certificates for him again, presumably still completely unaware of his old felony conviction. The source specifically mentions Davis carefully shielded his benefactors from the truth, understanding implicitly that if he disclosed the conviction, they might refuse to vouch for him.
Or they'd have to tell the board.
Exactly. which would have triggered a potentially fatal inquiry into his past.
So this act reinforced and compounded the original deception. He had another chance to come clean here, didn't he?
He did. At this crucial second stage, the point of seeking final admission to the bar, he had a second opportunity to disclose his past and trust in the system's potential for mercy given his rehabilitation. But he chose not to, doubling down on the strategy of concealment by omission.
And it worked initially.
On February 15, 1946, after years of hard work, studying, and careful planning, Samuel Wilton Davis's audacious dream became a reality. The Supreme Court of New South Wales, acting on the recommendation of the Barrister's Admission Board, which had been satisfied based on the certificates provided, formally admitted him as a barrister.
He took the oath, put on the wig and gown.
He did. He stepped forward, took the solemn oath to serve as counsel, an officer of the court.
It truly must have felt like a triumphant moment, a culmination of a decade-long effort to reinvent himself. A symbolic rebirth, maybe?
You'd think so. From a convicted lawbreaker who had stood in that very court building as a defendant, he was now authorized to practice law, to represent others, as an officer of that very court. He signed the bar roll and officially began practicing as a barrister in 1946.
How did he fare as a practicing barrister?
Notably, by all accounts available in the sources, in the brief period he actually practiced law for about a year, from early 1946 to mid-1947, there were seemingly no complaints or instances of professional misconduct attributed to him during that specific time.
The courts acknowledged that later.
Yes, the later court findings explicitly pointed this out, stating there was no evidence that he has been guilty of any misconduct that could unfit him for the bar apart from the original crime. And the fact that he procured the two solicitors to hold him out as a person of good fame and character without disclosing his criminal record.
So, putting aside the significant skeleton he had buried in his closet, he appeared to carry out his duties as a lawyer competently and ethically during that year.
For a time, it really did seem like he had successfully outrun his past, that his years of hard work and apparent reformation had permanently erased the youthful folly and its consequences. He might even have genuinely believed that his decade of good conduct and the respectable identity he had worked so hard to build meant the past was truly behind him, irrelevant now that he was on the right path.
But as we hinted at the beginning, the legal world, perhaps more than any other, has a very short half-life for secrets, especially those involving honesty and integrity.
They tend to come out.
By 1947, a year or so into his practice, whispers began to circulate about Samuel Davis. His story of dramatic reformation from a troubled youth to a practicing barrister was compelling, perhaps even too good to be true for some.
And the source suggests that someone, somewhere, tipped off the authorities about the truth of his concealed past.
The anonymous tip-off.
His felony conviction from 1935, the one he had so carefully and deliberately hidden for over a decade from his referees and the admissions authorities, was about to be revealed.
And it would catch up with him not through a client complaint or courtroom error, but through the very system he had sought to join. The shadow he thought he'd escaped was about to fully envelop his hard-won career.
And this brings us to the formal process by which the secret was uncovered and brought before the court in 1947, leading directly to the disbarment proceedings.
Okay, so how did it formally come out?
Mid-1947, approximately, is when word of Davis's concealed conviction reached the highest levels of the Supreme Court. The exact mechanism. While it isn't detailed in the sources, it remains somewhat of a mystery.
Could have been anything, really.
Was it a direct tip-off from someone who knew his history? Did a routine background check, perhaps triggered by something else, finally flag the old court record? We simply don't know the precise trigger.
But once the court knew.
What we do know is that once the information reached the court, the matter was formalized and investigated through the Office of the Prothonotary of the Supreme Court of New South Wales.
The Prothonotary, what's their role?
A senior court official responsible for various administrative duties, including those related to the roles of legal practitioners and the admissions process. The Prothonotary conducted an inquiry into the allegations and compiled a formal report for the Supreme Court judges detailing the findings.
And that report must have been explosive.
And that report contained, as the source puts it, the damning facts. It laid out in no uncertain terms that on both his 1944 application to become a student of law and his 1946 formal application for barrister admission, Mr. Samuel S.W. Davis had made no disclosure whatsoever of his March 1935 conviction for breaking, entering, and stealing.
The smoking gun.
The report's conclusion was clear and stark. He had obtained his admission to the bar under false pretenses by deliberate and material omission.
Armed with this report and the undeniable evidence, the the Supreme Court took swift and decisive action.
In mid-1947, the full court of the Supreme Court issued what is known as a Rule Nisi.
Explain that for us.
Think of it as a formal order from the court to the person concerned, requiring them to show cause why a particular action should not be taken against them. In this case, the Rule Nisi formally called upon SSW Davis to appear before the court and explain, quote, why he should not be disbarred and his name removed from the roll of barristers in light of these newly discovered facts about his concealed conviction.
So basically, explain yourself or you're out.
Pretty much. This was a dramatic escalation of the situation. The court was treating this matter with the utmost seriousness because it went right to the very heart of the integrity and trustworthiness of the legal profession itself.
Samuel Davis, who had been practicing law for a year, suddenly found himself a defendant again, facing the potential permanent loss of his right to practice law. As you can imagine, the stakes for him personally and professionally could not have been higher.
News of these proceedings and the underlying reason for them would have undoubtedly sent ripples through the relatively close-knit Sydney legal community. An admission scandal, particularly one involving a barrister already admitted and practicing.
That's rare.
Very rare, and likely became salacious fodder for discussion. Here was a barrister, one of their own, suddenly on trial for deceit, in the very way he had gained entry to the profession itself.
The case promised to force a difficult reckoning, didn't it? Testing that critical balance.
Exactly. That balance society often grapples with. Our interest in rehabilitating offenders and offering second chances versus the legal profession's absolute, non-negotiable need for honesty, trust, and integrity, particularly among those who serve as its officers and agents of justice.
You could see both sides, maybe. Sympathy for Davis.
Many might have felt sympathy for Davis, acknowledging his decade of genuine reformation. Others likely felt a strong sense of indignation that he had, in their eyes, gamed or subverted the system designed to vet for character.
But for the judges on the Supreme Court bench, the immediate question was clear, even if the answer was difficult.
Could a man with a serious past conviction, one which he had deliberately hidden during the application process, be allowed to remain a member of the bar?
And critically, did the Supreme Court even have the power, under the relevant legislation at the time, to remove him from the role, given that he had technically met the formal requirements?
By presenting the certificates, right? And his misconduct was before he became a barrister. That was a key legal question they had to resolve.
And this set the stage for the dramatic showdown in the Banco Court in October 1947. The Rule Nisi, the order to show cause, was scheduled for a formal hearing before the same three Supreme Court judges.
On October 14, 1947, the case of Inner Samuel, Sidney Wilton Davis, as it was formally styled, was called in the Banco Court.
The courtroom, as we imagined, was likely tense, filled with other lawyers and court personnel keenly observing this unprecedented scenario. Samuel Davis stood as the respondent, the party against whom the proceedings were brought, required to respond to the court's order.
While technically the proceedings were brought by the court ex parte, meaning on its own motion, the Bar Association stepped in, representing the public interest and the maintenance of professional standards.
So they weren't formally prosecuting him, but...
As the source puts it, they appeared to assist the court in presenting the facts and arguments necessary for the court to make a decision. For all practical purposes, it was effectively Samuel Davis v. the legal establishment, a direct challenge to his right to belong to the profession.
Okay, let's talk about the legal teams. The appearances for this crucial hearing reflected the high stakes. Who was arguing for Davis?
Appearing for Samuel S.W. Davis, the respondent, was none other than Garfield Barwick K.C., described as a formidable advocate.
The future High Court Chief Justice.
Exactly. Barwick was assisted by junior counsel Mr. Clapham. As we noted earlier, Davis, facing such a challenge to his career, truly could not have chosen a more illustrious defender to represent him. Instructing Barwick K.C. and Mr. Clapham was the solicitor Mr. K.V. Swain.
And arguing against him or assisting the court?
Appearing for the Bar Association, assisting the court, were Clifton Fuller K.C., a senior barrister himself, and his junior, Mr. Street.
The other Mr. Street.
Yes, not Justice Street on the bench. Fuller and Street were effectively acting as the advocates presenting the case for why Davis's name should be struck off the roll, arguing that his conduct rendered him unfit. Instructing Fuller K.C. and Mr. Street was the prominent Sydney law firm, Allen and Hemsley.
So the legal teams were assembled, the arguments were prepared, and the legal battle over Davis's future commenced. Garfield Barwick K.C., representing Samuel Davis, rose to address the court. His task was, as the source noted, indeed Herculean.
Absolutely.
Yeah.
How do you effectively defend the man who deliberately hid a felony conviction to gain entry into a profession that demands absolute honesty, particularly when the concealment itself is the main issue?
What was his strategy?
Barwick likely began by focusing intensely on Samuel Davis's life since the crime occurred in 1934. He would have emphasized Davis's remarkable rehabilitation and exemplary conduct over the preceding decade and more since 1935.
Play the redemption card.
Essentially, yes. He painted a picture of a man who had genuinely overcome significant adversity, the youthful mental breakdown, the unfortunate brush with criminality, and who had then dedicated himself to redeeming himself through years of diligent effort, honesty, and hard work.
He'd point to the war work, the studies.
Barwick would have highlighted Davis's solid citizenship, his efforts in wartime industrial work, his perseverance in undertaking rigorous legal studies. He'd argued Davis showed extraordinary industry, perseverance, and courage amidst the most adverse circumstances, noting, as one source opinion did, that he had overcome many disadvantages.
Trying to build sympathy.
Barwick likely made a powerful, perhaps emotional appeal to the judge's sense of mercy and human sympathy, arguing that Davis's difficult past, including the mental breakdown and even his descent into criminality, were tragic chapters that will evoke much human sympathy. He would have implicitly but strongly questioned whether it was truly just or necessary to destroy a man who had so completely turned his life around by disbarring him now.
Especially since he seemed to be practicing okay for that year.
Exactly, given his seemingly ethical conduct as a barrister over the past year.
But what about the legal arguments, the concealment itself?
Then came the crucial technical legal argument. Barwick contended that Samuel Davis had, in fact, fulfilled the formal requirements for admission as they existed at that time.
Meaning?
He argued that nowhere in the written rules was a candidate explicitly required to volunteer information about past convictions unless specifically asked on a form. Davis had supplied the required character certificates from Mr. Wishart and Mr. G, as mandated by the rules. The barrister's admission board, based on that information, had been satisfied.
And he pointed to the legislation.
Barwick seized upon the wording of Section 10 of the Legal Practitioners Act, 1898. That section stated, quite mandatorily, that every candidate whom the board shall approve as a fit and proper person shall be admitted by the court.
Shall be admitted. Sounds mandatory.
Barwick argued this meant the court's role was simply to admit those approved by the board. He contended the court had no discretion to refuse admission once the board approved, and by extension, he argued, the court shouldn't now have the power to undo that admission unless there had been misconduct after admission.
Since Davis hadn't misbehaved as a barrister,
Barwick argued he had done all he need to under the existing rules.
did he address the fact Davis knew he was hiding something significant?
He also attempted to draw a distinction. He argued Davis hadn't technically lied to a direct question because there wasn't one. He withheld the truth, yes, but the rules, Barwick might have contended, didn't plainly compel disclosure of spent convictions at that time, especially since the bond meant no prison time.
It's a fine line.
A very fine line. Barwick likely also raised the specter of a slippery slope. If every applicant had to volunteer every past mistake, where would it end? He pressed the point that there was no explicit obligation for Davis to inform the board or his referees. He'd simply chosen silence to avoid prejudice.
Urging compassion.
He urged the court to view Davis's case as unique, worthy of exceptional compassion, and not let this one youthful mistake forever bar a reformed man. He argued disbarment was disproportionate.
Okay, so that was Barwick's case for Davis. What about the other side? Clifton Fuller K.C. for the Bar Association.
Clifton Fuller K.C., speaking for the Bar Association and upholding the public interest, presented a starkly different message. His focus wasn't primarily on Davis's personal redemption journey.
But on the profession itself.
Exactly. It was squarely on the integrity of the legal profession, which he argued had been fundamentally compromised by Davis's actions.
How did he frame it?
Fuller wasted no time. He identified Davis's failure to disclose his conviction as a grave breach of trust, not just to the board or his referees, but ultimately to the court itself. His core thesis was simple and powerful. A man who obtains admission by concealing a serious criminal offense is inherently unfit to be a barrister.
It's about honesty.
The case, he argued, wasn't complex. Fundamentally, it was a matter of honesty.
He argued Davis intended to mislead.
He contended that Davis had intentionally misled the very gatekeepers, the board and the court. Fuller argued convincingly that if the truth about the 1935 conviction had been known in 1946, the board and the court almost certainly would have rejected his application or, at minimum, inquired much deeper. Therefore, his admission was not honestly obtained.
How did Fuller counter Barwick's argument about the lack of an explicit question?
By asserting there was nonetheless an implicit and fundamental duty of candor resting on every applicant. He stated clearly that Section 9 required a candidate to satisfy the board that he is of good fame and character, and that couldn't be met by trickery or half-truths.
So just getting references wasn't enough.
Not if you hide vital information from those referees. Fuller argued powerfully the law implied full disclosure of anything relevant to character, perhaps so obvious that perhaps wasn't spelled out explicitly. Hiding a serious crime, he contended, means you aren't of good fame and character if you haven't come clean about it.
By keeping silent, Davis denied the board the chance to do its job properly.
Fuller argued Davis had subverted the very purpose of the character inquiry. He denied the board and court the chance to exercise their essential gatekeeping role with all the facts. Had he been frank, the outcome might have been very different.
And Fuller likely stressed the special nature of the legal profession.
Absolutely. He likely invoked lofty principles, perhaps citing words Justice Dixon would later make famous, emphasizing that the bar is no ordinary profession. He stressed that counsel must command the personal confidence of other members of the bar and of judges.
Trustworthiness is key.
To do this, a barrister must be scrupulously honest. Fuller pointedly asked how Davis could possibly be trusted now, knowing he'd gained entry through deceit.
What about the message it would send if Davis stayed?
Fuller argued forcefully that allowing Davis to remain would send a disastrous message, that honesty is optional for lawyers. This, he argued, would severely erode public confidence.
And on the technical point about the court's power under Section 10,
Fuller tackled Barwick's argument head-on. He asserted strongly the Supreme Court's inherent authority to supervise its officers, including discipline and removal for reasonable cause, even for antecedent conduct.
So conduct before admission still counts?
Yes. He argued the idea that a fraudulently procured admission could somehow make someone immune from removal under Section 10 was absurd.
He probably cited precedents.
Likely cited previous cases affirming the court's power. He underscored that maintaining standards is paramount for public protection. He argued powerfully that while sympathy for Davis was proper, it was no reason whatever for impairing the standards of a profession which plays so indispensable a part in the administration of justice.
Public duty over individual concern.
That was the core message.
The hearing would have involved tough questions from the bench, I imagine.
Absolutely. Chief Justice Jordan and the other judges likely questioned both Barwick and Fuller extensively on the scope of the duty of candor, the interpretation of Section 10, alternative remedies.
Trying to get to the heart of it.
Based on the eventual judgment, it's clear the judges were ultimately persuaded by the Bar Association's arguments about integrity, candor, and the court's inherent power, even faced with Davis's sympathetic story.
After all the arguments, the court needed time to decide.
After hours of intense legal submissions, arguments, perhaps considering an affidavit from Davis himself, the court adjourned. The traditional Latin phrase, cur ad vie volt, was pronounced. The court wished to consider its verdict.
A nervous wait for Davis.
For Samuel Davis, this must have been a torturous waiting game. The fate of his hard-won legal career, the respectable life he had built hung by a thread, dependent on how these three judges weighed his rehabilitation against his fateful silence. The tension must have been immense.
The wait wasn't long, though. Just 6 days later, on October 20th, 1947, the Supreme Court reconvened to deliver its judgment. Chief Justice Jordan read the decision of the full court.
And the outcome was, for Samuel Davis, a devastating blow. The court made the rule nisi absolute.
Meaning
the order requiring him to show cause why he shouldn't be disbarred was made permanent. Samuel Davis was formally ordered to be disbarred, and his name ordered to be struck off the roll of barristers. Permanently expelled.
Wow. What was the core reasoning?
The core reasoning, delivered by Jordan C.J., was unequivocal. The judgment stated in no uncertain terms: a person who has been convicted of a serious criminal offense and who procures 2 solicitors to hold him out as a person of good fame and character without disclosing his criminal record, has failed in his duty to the court, and consequently he should be disbarred.
So the concealment was the key breach.
The court viewed Davis's concealment not as a minor error, but as a fundamental breach of duty to the court itself. By hiding his past, misleading his referees and the board, Davis had subverted the integrity of the admissions process, an egregious act of bad faith.
Did the judgment address Barwick's technical arguments about the court's power?
Meticulously. On the court's jurisdiction, Jordan C.J. cited historical authority confirming the Supreme Court's inherent power to remove a barrister for reasonable cause, even if the cause related to conduct before admission.
And the board couldn't remove him?
Jordan C.J. clarified the board had power to admit, but not remove. That power remains solely with the Supreme Court.
So if admission was improperly obtained,
The court must have the power to correct that flaw. Jordan C.J. was clear. Section 10 did not remove the court's power to ensure the fitness of those on its roll. The High Court later strongly agreed.
And what about the duty of candor? This seems central.
Then came the part that established a clear and lasting precedent, the declaration of the implicit fundamental duty of candor. Chief Justice Jordan completely rejected Barwick's argument about just finding 2 referees and staying silent.
He didn't buy the no specific question argument.
Not at all. He stated clearly, it is quite clear from S9 that it is the duty of a candidate to satisfy the board that he is a person of good fame and character, and that duty could not be met by trickery or suppression of material facts.
He was quite scathing about it.
The court was. Jordan C.J. stated emphatically, I entirely disagree with this. He elaborated that being a barrister involves a peculiarly confidential relationship, calling for complete integrity.
So hiding a serious offense makes a mockery of the character requirement.
Exactly. Allowing someone to gain admission that way would make a mockery of that principle. This judgment effectively set the precedent. Full and frank disclosure is expected. Anything less is a violation of duty.
Did they reference other cases?
Jordan C.J. cited an earlier Queensland case, in Re Watson, supporting the principle that admission could be vacated if improperly obtained, which the court found was precisely what happened here. The board and court were misled.
And the High Court later agreed on that point, too.
Yes. Justice Stark later bluntly said the board and court being misled was sufficient ground for disbarring.
Did the Supreme Court acknowledge Davis's rehabilitation efforts at all?
They did. The panel noted his positive developments since 1935. However, they drew a firm line. While sympathy could be evoked, the court stated, such sympathy is no reason whatever for impairing the standards of the profession. The bar's integrity was too vital.
Was there any comment on whether someone with a criminal past could ever be admitted?
A particularly striking passage, later quoted by the High Court, highlighted the condition. The court stated that even theoretically admitting someone with a criminal past would absolutely require, quote, a complete realization by the party concerned of his obligation of candor to the court.
And Davis failed that test?
Manifestly failed it, the judgment implied. The High Court later noted the obligation of candor with its attendant risks proved too painful. He withheld the fact. By not owning up, he essentially forfeited any claim to leniency and showed a lack of required integrity.
So the conclusion was unavoidable.
In concluding, Jordan C.J. likely expressed regret for Davis personally, but condemned the deception. Could the bar make room for a reformed ex-criminal? Perhaps, but only if entirely truthful from the onset. Davis chose differently. The answer was uncompromising. Order pronounced. Disbarred.
As the gavel fell, Samuel S.W. Davis's brief career as a barrister came to a sudden and humiliating end. He walked in a barrister, left an ordinary citizen, name erased, rise undone in a single moment.
Based not on the past crime, but on the present dishonesty in gaining entry.
The public and press noted it. Aspiring lawyers learned a hard lesson.
Absolutely. No matter how reformed, deliberate concealment was viewed as an unforgivable sin by the courts.
Samuel Davis, however, wasn't quite finished fighting. He appealed the disbarment decision to the High Court of Australia.
His last hope to reclaim his status.
The appeal was heard later in 1947, specifically in December, before a panel of 5 High Court justices, Chief Justice Latham and Justices Stark, Dixon, McTiernan, and Williams.
His counsel, likely Barwick again, would have reiterated the key arguments. Good conduct, lack of explicit duty to disclose, Section 10, perhaps arguing disbarment was too harsh.
But the High Court's ruling, delivered on December 15, 1947, was definitive.
Definitive and powerfully unanimous on the core issues. They firmly dismissed Samuel Davis's appeal. The High Court justices agreed with the Supreme Court and upheld his disbarment.
They agreed the Supreme Court had the power.
Yes. Agreed the Supreme Court had full authority to refuse or undo admission, if not fit and proper. Chief Justice Latham, though dissenting on a minor technical point, concurred unequivocally on the main issue. He stated the Supreme Court rightly held Davis unfit to continue.
What about Justice Stark?
Justice Stark, blunt as ever, reiterated that if the truth had not been suppressed, he wouldn't have been admitted. Both the board and the court were misled, and this in itself is a sufficient ground for disbarring. Confirmed, deliberate suppression is grounds for striking off.
And Justice Dixon's famous words came from this case.
Perhaps the most enduring and widely quoted words came from Justice Owen Dixon. In a separate concurring judgment, Dixon eloquently articulated why the bar demands such uncompromising honesty.
What did he say?
He famously stated, "The bar is no ordinary profession or occupation. The duties and privileges are such that counsel must command the personal confidence of other members of the bar and of judges."
It's about that relationship of trust.
Dixon saw it as a relationship of intimate collaboration with the judges, carrying exceptional privileges and exceptional obligations. If a barrister lacks honesty and integrity, he is not a fit and proper person to remain at the bar. A clear endorsement of excluding Davis.
Did the High Court also address the sympathy aspect?
Another judge, likely Justice Williams, acknowledged Davis's favorable qualities, hardships, his tale evoking much human sympathy.
Lord.
But concluded, echoing the Supreme Court, concern for an individual is very proper, but it is no reason whatever for impairing the standards of a profession. Integrity of the bar trumps personal plight.
Did the High Court also comment on candor being essential for rehabilitation and admissions?
A particularly telling passage addressed this. The court acknowledged maybe, hypothetically, someone with a past could be admitted after proven rehabilitation.
There was a big condition.
But a prerequisite, the High Court stated, in any case, would be a complete realization by the party concerned of his obligation of candor to the court. Absolute non-negotiable starting point. Full honest disclosure up front.
Yes. And Davis failed this.
The judgment pointedly analyzed Davis's actions. The fulfillment of that obligation of candor with its attendant risks proved too painful for Davis. He withheld the fact.
He wasn't willing to risk rejection by being honest.
Exactly. He chose concealment. By doing so, the High Court found he demonstrated a lack of the very integrity the profession requires. Therefore, the conclusion that he is not a fit and proper person is confirmed. Chief Justice Latham agreed. The order made was inevitable.
And with that final word from the High Court, Samuel Davis's legal saga ended.
In finality. Appeals exhausted, left to pick up the pieces outside the law. Personal despair. Name publicly associated not just with a past crime, but with dishonesty in becoming a lawyer.
His hard work and reformation overshadowed by the deception.
Ultimately, yes. For the court and the bar, though, it was a necessary reaffirmation of core values. The precedent set by Henry Davis would echo through the decades. A powerful warning.
And that brings us to the aftermath and the lasting legacy. Henry Davis sent shockwaves through the legal community.
Absolutely. It became a foundational precedent cited repeatedly in legal ethics and professional admissions cases, not just in Australia, but influencing common law jurisdictions.
What happened to Davis himself?
The aftermath was undoubtedly bitter. He likely faded into relative obscurity, ambition unrealized. His name became a byword for honesty being paramount, pride overshadowed by the stigma of deception.
But for the legal profession, the case remains a touchstone. What are the key implications?
Several key legal and ethical implications continue to shape the profession today.
The most obvious one must be the duty of candor.
The most prominent legacy, the duty of candor in admissions. In reality, Davis firmly established an applicant has an affirmative duty to disclose all material facts about their past bearing on fitness and character, even if not explicitly asked. The onus is on the candidate.
It's not a minor detail.
No, it's fundamental. Hiding is viewed far more harshly than the wrong itself, especially if there's genuine rehabilitation. Davis is the prime example. Not the burglary, but the concealment disbarred him.
And modern application forms reflect this.
Modern forms explicitly require disclosure of criminal convictions, even spent ones, charges, discipline, bankruptcy, academic misconduct, anything reflecting on character. Often requires statutory declarations, making non-disclosure potentially perjury. The lesson from Davis: the risk of hiding is far greater than the risk of candid disclosure. Candor is non-negotiable.
The case also vividly illustrates the fit and proper person test.
Absolutely. Character is key. Fit and proper. Davis makes it clear character isn't just a formality. It's central, equal to skills. Integrity and honesty are the bedrock.
Why is it so crucial?
Dixon's words capture it. Lawyers hold deep trust clients, court, public. If authorities can't trust an applicant about their own history, how can they be trusted with client secrets, money, or court duties? Ethics courses often use Davis to show character matters profoundly.
It also confirmed the court's power to discipline.
Yes, the inherent jurisdiction confirmed. Superior courts have inherent power to supervise the profession, including disbarment for reasonable cause, even for antecedent conduct discovered later. This is now ingrained in modern statutes. Davis is an early, emphatic statement: courts will protect the role's integrity.
And it highlights that tension between rehabilitation and protecting the public.
The enduring tension, balancing rehabilitation versus public protection. Davis seemed genuinely reformed externally, but the profession's primary duty is to the public and justice administration. Davis leans heavily to the latter. Standards can't be impaired for an individual.
So redemption is possible, but requires
Complete honesty and transparency, not just staying out of trouble, but acknowledging the wrong and the duty of candor. Compassion can't override the need for integrity in those administering justice.
Finally, the case's influence on modern standards is undeniable.
Profound influence on modern standards. Current rigorous application processes, explicit disclosure requirements, statutory declarations, partly a direct legacy of Davis. Dixon's words are quoted to new lawyers constantly.
Samuel Davis's story, its ambition, resilience, impressive reformation in many ways.
But also the tragic cost of a single monumental lie by omission. The drive that helped him reinvent himself also led him to hide his past, destroying his future in law.
In Retrace, Davis remains a chillingly powerful landmark case, a reminder that the truth eventually will out.
Especially in a profession built on truth.
For the legal profession, it reinforces a demanding ideal. Advocates must be as upright, candid, and honest as the law itself.
Davis's rise and fall leaves a stark, simple creed. Never hide the truth, especially when seeking entry into a profession built on trust. There's no room for fundamental deception about oneself.
And that leaves us with something important, perhaps difficult to ponder. Davis's story forces us to think about that tension. Second chances versus the absolute need for candor in guardians of the justice system. Could his story have ended differently if he'd told the truth from the start?
Risking rejection, but proving present honesty. Or was the original crime itself too much, even with candor? Does society truly believe in rehabilitation if a past mistake, even overcome, can derail a career if not confessed?
Or, as the courts concluded, was the specific crime of deception at the point of entry uniquely disqualifying for a profession based utterly on trust? It wasn't the burglary, it was the cover-up.
As in Davis stands testament, echoing through the decades, integrity is the highest law for those who would uphold the law.
A powerful thought to end on. That's all for this deep dive.
Until next time.